Thank you. Thank you for being here. Good morning to Mr. Soto del Toro and Ms. Hernandez. And then I believe we have Mr. Gojak on this case on behalf of one of the parents. Good morning. And we do have Ms. Farr on this case. There you are. My screen has so many participants. Good morning, Ms. Farr.
Good morning.
Maybe I'll start with Mr. Gojak. Any updates since our last hearing?
Yes, Your Honor. My client has signed the consent to the guardianship. I still need to file it, but it has been signed and provided to, actually, the other parties provided it to me. So everybody does have it.
Ms. Farr, I'll turn it over to you for an update on your end.
So both parents have consented, and I have sent the proposed findings to Mr. Gojak for his approval and signature. We're just waiting for everybody to sign and we can present it to the court.
And I do see the two consents on file on my end as of October 13th, I believe. So thank you for filing those. So Ms. Farr and Mr. Gojak, it sounds like maybe we just need a presentation date, as it sounds to me like this will be essentially an agreed minor guardianship order. Does that sound correct?
Yes, Your Honor.
Sí, señoría.
Yes.
Sí.
When would you like me to set this for presentation? Just in 1 week?
1 week should be sufficient.
Debe
Agreed.
ser suficiente una semana, de acuerdo.
And let the guardians know what we are doing here today and see if they have any questions. So do you understand what the court is doing today? Essentially setting a final hearing for me to sign the guardianship order, assuming all the terms are agreed to?
Sí.
Yes.
Do you have any questions for the court?
No, todo está bien, gracias.
No, everything is fine. Thank you.
Ms. Farr, Mr. Gojak, I know work for Ms. Hernandez is difficult to get time off. Would the two of you be okay waiving her presence next week if everything is agreed? Go ahead, Ms. Hernandez, sounds like you may want to jump in.
Adelante, señora Hernández.
Yeah, I know for a fact that my mom is gonna want to be there. She is more than willing to miss work because she wants to. It's been a very long process.
Okay.
It's been a lot of work, and my mom has been at the front of all of that. So I know for a fact that my mom's gonna want to be there for that. And thank you so much to Sherry Farr and Mr. Dino Gojak. I really appreciate, and all the translators who have helped my family. And you, Miss Your Honor, it's been, yeah, I'm very appreciative of everything. Thank you.
Sounds like to the interpreter, I'm fine without you interpreting that.
And I'll tell him, and he knows.
Okay.
He's fine.
Sí entendió usted, señora.
Yeah.
I know the daughter has been acting as an interpreter before we were able to get a formal interpreter on board. So thank you. Okay, so let's set next Tuesday, which I believe is at the 24th, October 24th at 10:30. And my assumption at that time is the court will just be reviewing the agreed orders and signing them. Head Ms. Farr.
If you would waive my appearance for that day, I'm in trial in Clark County, and Mr. Gojak can go ahead and enter with my signature.
Absolutely. We will waive, and I do recall that from last week's discussion. So we will waive your appearance. Absolutely.
Ms. Farr, if you could resend me that finding in order, I was not able to find it. So please and thank you.
Go ahead.
Sí, mi pregunta es, ¿vamos a asistir a corte o va a ser igual por Zoom?
My question is, will we be attending in court or will it also be via Zoom?
Also via Zoom next
Okay.
week. Okay.
Okay.
Okay, if there's nothing else on this case, you're free to log out. Thank you so much for being here.
Sí, no hay nada más,
And I
entonces-
believe I have Tammy Cost online. She's the proposed guardian in this case and the tracking case. And I have Ms. Gilliam present.
Okay. No, Your Honor. Your Honor, I did tell Samantha that she could be at school today instead of being in court for purposes of today. I anticipated the set over.
Perfect. That is, so I'll just tell the folks, this is what I saw on this case as well. So we have Ms. Cost originally filed for emergency guardianship. And that's under a different docket that I've already set to October 31st. Ms. Brightmeyer, on her own accord, filed for this minor guardianship and asked to have counsel appointed. I reviewed under this docket her request for counsel and denied it ex parte only because we had already appointed Ms. Bliss on Ms. Koss' emergency minor guardianship case. So what I would like to do, absent any objection, is simply consolidate these two matters and have it all heard on the 31st as originally proposed. Is that okay with everyone involved? I think I'll start at Ms. Bliss. It sounds like that was your request anyway, so you're probably in agreement.
That is correct.
Mr. Anagnosto.
That is not okay with my client. Her daughter is suffering from mental health issues and it's untreated, and she needs her return sooner than later.
Okay. And Ms. Cost.
That it works for us. Ms. Brightmeyer is in mental health services and has been for a couple of weeks now. So her needs are being met.
Okay. Go ahead, Ms. Gilliam. You do have an attorney, so you're free to talk to the court, or I can give you a breakout room with your attorney.
I was not aware that she was in mental health services.
Do you all want a breakout room to talk about this?
Me and my client?
Yes.
No, I think because my client is way more knowledgeable about the facts. I've been reviewing it this morning, trying to get up to speed. I didn't realize I was on this docket, but if the court would just indulge her to hear from her, but it sounds like she wasn't aware that her daughter was in mental health, and I'm not sure if she has any input regarding that.
Okay. So Ms. Gilliam, you do have an attorney now, so I don't want to, force you to say anything. I think the question is just because when we were all together last, we had set the October 31st date. Do you have an objection to us consolidating this case and hearing it all on the 31st, knowing now that at least by Ms. Koss' assertions, she is in mental health treatment?
No, Your Honor, I'm fine with consolidating everything.
Okay. So it sounds like, and I do think just out of economy of fact finding, I do think on the 31st that will also give the attorneys who have recently been assigned more time to prep for fact finding. I will just note kind of historically, this is a case where Judge Warning already had a fact finding and denied the petition. And so I guess I just want to give the attorneys plenty of time to prep for what sounds like maybe some facts that came up since that denial. And it doesn't sound to me like this is a case where we're going to just do a bunch of continuances. I do really believe we'll move to a fact finding on the 31st since we've kind of already been there once. Okay.
And Your Honor, just procedurally, the fact finding, is that going to be testimonial, or does everything have to be done by declarations?
I will allow some testimony. I guess what I'll tell the parties is my preference on the emergency guardianship fact findings is that it's pretty limited. If you all think you're going to be spending more than 30 minutes on the case, I would want to set it to a different docket. I mean, technically we set this docket for 1 hour to hear everyone's minor guardianship cases. So if you think that testimony is going to be lengthier, let's maybe get this noted on an earlier docket and get you special set or something like that. But typically what I've done is allow parties about 15 to 20 minutes of testimony that I'll consider in addition to declarations on the emergency piece. And then if we need to trial set for the full petition, we certainly can.
Okay, very good, Your Honor.
Okay. Okay, so what I'll do is move this over to the 31st. This one does not have any sort of guardianship order that I need to continue. That's already been done on the emergency case from Ms. Cost. So we'll see you back on the 31st.
Thank you, Your Honor.
We have Mr. Sasaki present. Am I pronouncing your name correctly?
Correct. Thank you, Your Honor.
I'll say that just as a blanket statement to everyone. I'm not the best with name pronunciations. Don't feel bad about correcting me if I get your name wrong. And I do have the proposed guardian here. And Ms. Powers, you're also on this case, I believe.
That's correct.
Okay, I'll just let the parties know what I did see since our last hearing was the proposed consent by father. It is the consent document. The actual document isn't signed, but it has an attachment that appears to be his statement and signature. So I have received that. So let me, I guess, whether Mr. Sasaki or Ms. Farr wants to go first and give me a brief update on where we are at and what's being requested of the court today.
I can start off unless Ms. Farr prefers. Okay, well, unfortunately, Your Honor, we still, even after several attempts from both sides, ours and our clients, we still haven't been able to communicate with our client, either via phone or written. He's an inmate in Spokane, and so that complicates things. We did notice that the consent form, unsigned, is an odyssey, along with a letter that is signed. And so what we did is our office on Friday, we mailed to him a copy of the consent form and asked if he truly does consent to have a signature on that form as well, and to mail back to us in a stamped and self-addressed envelope, which if he turns it around, we could get that within, I think, by next Friday or so. But with regard to the emergency guardianship as a practical matter, I don't think there's anything. I mean, the consent is for the full guardianship, but I mean, he's incarcerated in Spokane, and so I under the circumstances, I wouldn't think that there'd be any objection to the emergency guardianship itself either.
Okay. Ms. Farr, I'll turn to you.
I mean, I believe the consent as filed should be accepted by the court. I don't, the reason that there was the separate letter was because it was printed on double-sided, and I don't think that he saw the second side to sign, and so he completed it by the handwritten letter. My understanding was that we were going to be entering the final orders, that you were just waiting for my report, which I haven't got filed yet. And so I was just going to ask for another week or two to get that in so we can get the findings completed.
Okay. And then
I may speak to that.
Yes, go ahead.
Sorry, Your Honor. 2 weeks would be preferable, just so that if he does, the father does mail that consent form signed to us, then that would give us some more time to have that on hand and to file that with the court. It sounds, I mean, under the circumstances, the letter is signed. It just concerns me if he didn't read that page 2, that you know, he would. It would be best for him to read and sign that page 2 in order to get his informed consent.
And then any input from the guardian here?
Yes, Mr. Layton called. He does a phone call and talks to, well, his daughter, but talks to me. And he called last night and said that he did sign that paper and send it back.
Okay. And Ms. Powers, any input from the state? I mean, it sounds like we're just at this point, I think my inclination is to set it out 2 weeks so I can receive the final GAL report. Any input from you on a 2 week set over to finalize this matter?
I have no objection to a set over. I am curious whether the court has our proposed child support orders. We sent them over at some point, but I don't know if they've trailed with the case as the hearings have been set over.
Let's see. Oh, we do have them. So if you don't anticipate changes, we'll just move those over to the 31st.
Perfect.
Okay. And then this was just, so we will set this to October 31st, if I'm not mistaken, at 10:30 a.m. I would say, you know, I would prefer, I mean, I think the consent is probably okay as filed, But I think my preference, because I do know on that second page, there's a lot of language about, hey, make sure you know you're giving up XYZ. My preference would be that he does sign that second page and get it filed. So to the guardian, if you do talk to him again and want to let him know, hey, your attorney sent you paper and the court really wants it back, I think that would be helpful, because it sounds like he's not having great communication with his attorney. So that would be my preference, but you know, I'm not gonna, assuming everything else is in order, I wouldn't say that's going to be a reason that I would deny signing the order by any means. One just housekeeping matter, and this is a question I have on another case too, is DCYF, when the court signs the motion or the order to release confidential information, do they only respond if there is information to report? Because I'm just rarely seeing any response from them on any case. Do you know, Ms. Farr?
They're supposed to respond either way. It will either come back and say no records found or provide the information. And I have noticed the same issue. I know. So it looks like it was sent only a month ago, 9/20. So maybe we're just kind of in the period still waiting, because usually they respond within about 3 to 4 weeks at the most.
Okay.
But I have noticed that on other cases too, where we've had to request it a second time, a follow-up. So
okay. And I would say that was kind of my only note I made for myself is, hey, you know, one of the things I have to sign is that I have received that information back and I've reviewed it. So I don't think I could finalize an order without some sort of response back from them. So I guess I'm just kind of throwing that out into the universe for follow-up somehow.
So I can check with the clerk's office and see if they can follow up.
Oh, is that who does it? The clerk's office?
The clerk's office sends it, and then DCYF or CPS sends it back to the clerk's office. We don't get notified when it comes back. We just have to keep following up.
Okay, the clerk is giving me some input too. Hold tight.
I was gonna say, I send it, but I don't get any response back. It's just to a portal that basically takes the documents and nothing else.
Oh, gotcha.
So the petitioner can call DCYF. I don't know the contact information, but they can follow up with it.
Okay.
That would be the only other option that there is.
Okay. So what the clerk is letting me know, because essentially this form gets sent to kind of a template email. It's really not to a person, and they don't get any like delivery or read response back. So the best thing to do in this scenario, so that ma'am, petitioner, you don't have to keep coming back to court and me saying, I don't have that information yet. You can call DCYF, give them the cause number and follow up with them and just say, hey, can you please get this information filed? Okay.
Okay. I'm not understanding I'm lost.
Okay, so I'll back up just a little bit. So when you filed your original petition for the emergency guardianship, one of the standard forms that goes with the packet is, and I'm just going to get down to the date of it in your case, it's a motion for order directing DCYF to release CPS information. Do you recall that? It's something that you signed and filed with your petition.
Yes.
Okay. So you're calling DCYF to follow up on, hey, you guys haven't sent in the information to the court yet. And usually that information is hopefully, there's no record in the system of any action with this petitioner and child or petitioner. Or, hey, here's a list of things that we have.
Mm-hmm.
Okay.
Yeah.
Okay. So that'll be your only homework. So we'll still set this out 2 weeks in the hopes that they will respond by that time, but I will need that before signing the order. So that's your only homework between now and our next hearing. Okay.
So DCYF, is that like at Child Protective Services?
Yes. Yep.
Okay.
Okay.
Got it. Okay.
Anything else on this case?
Oh, Your Honor.
Okay, I will extend the emergency order, the immediate emergency order through October 31st, and I'll get that filed later today.
I don't have any information about the attorney or if somebody's covering for him.
Okay, let me do this. I know I have one other case. Well, no, I have two other cases. Shoot, I don't want to make you guys wait that long. I know Mr. Gooday is in trial in the courtroom right behind me. Let me call one case before yours. I'm going to see if someone can get a note to Mr. Gooday to see if he's having someone else appear. Ms. Muldoon, have you had a chance to talk to Mr. Gooday?
No, Your Honor,
Yeah.
I have not, but
Okay.
I have talked to the guardian ad litem.
Okay. Let's,
So, Your Honor, it may make sense just to set it over a week. Both the petitioner and the mom are here. I've made arrangements to meet with both of them.
okay.
And so maybe if everybody is agreeable to that, we could set it out a week and just come back next week when Mr. Gooday is available and we'll have a little bit more information.
Let's just drop something. Ms. Muldoon, I don't want you to say too much because you are represented and he isn't present, but I know that he is in trial and it's, I think unexpectedly in trial today. So are you okay with just a 1 week set over to give you time to actually speak with your attorney?
Yeah, I was actually gonna ask who my attorney was in this matter, Your Honor. Because I didn't hear from anybody this last week, so I was just gonna ask today and figure it out with you guys to who my attorney was. So now I know.
Okay. And Miss Redden, are you online with us?
I am.
Okay. Hate to do this to all of you. I know you've been here several weeks in a row, but are you able to log on next week, the 24th at 10:30?
We are. I just have one question though for you guys.
Yes.
Austin does have an upcoming dentist appointment and they are asking for him to be put under for the dental work. Is that something that will be okay to do?
I believe on the emergency guardianship, you have healthcare decision. Yep. You have healthcare decisions now in the order that I have signed, and I'll be re-upping that order just for 1 week.
Starting now. Oh, sorry about that. Okay. Well, I just wanted to also let Bree know that he is going to have some dental work done.
Okay.
Thank you. Yeah, I think she would appreciates that. And I thank you both for working so well together as always, as I always see you both do. So thank you. Okay. I think that makes a lot of sense. So we'll set this over 1 week. We'll get notice to Mr. Gooday and be back next week, Tuesday at 10:30 a.m. Okay.
Thank you, Commissioner.
Thank you, Your Honor.
Ms. Farr, are you also on this matter?
Yes, Your Honor.
Okay. I'm gonna pull this digital file up, but when I reviewed it, my notes indicated I have received consent forms from Mr. Phelps and Ms. Dietrich.
Correct.
Okay. And Mr. Phelps, you are here with us. Thank you for being patient.
Not a problem.
Okay. So Ms. Farr, I'll turn to you first.
Yes, Your Honor. So I am just beginning my investigation on this matter. I did see the parents' consent. I haven't confirmed with either one of them or explained to them what their rights are. We still need service on the parents. We need the declaration of training, which I just sent to Molly yesterday. And I have received a phone call back from father and I need to return that to set up an interview with him. Okay. So we're still kind of in the beginning stages, but I don't anticipate it will take too long if we can just set this over a couple weeks because it looks like it's consented to.
Yeah. And Mr. Phelps, what all that means is we do have your consents, but the court still needs to take a few extra steps to make sure both parents have received all the documents in this case, that they understand what their consent means. And then this is a case also where I noticed we don't have DCYF response yet, so we'll certainly need that. So Ms. Curry, like you heard me say to the other individual, it hasn't been that long. I think the order was only signed September 20th. So, it's not like they're delaying a response, but if you want to reach out to kind of gently nudge them and remind them to get that to us that would be a piece of homework I could give you before the next hearing. So Ms. Curry, any questions for the court? Otherwise, I think my inclination is to set this out probably, I would say just because, well, maybe especially because of DCYF, maybe 3 weeks. And then hopefully we won't have to do another set over, like we can actually just finalize at that time is my hope.
Okay, that's fine. When I talked to Miss Farr yesterday, Brian and I, he comes to visit Lila. We're all okay. The only problem is finding Emily. I was able to get this consent. It's months to find her. She's active user and homeless, so I have to keep trailing her every single day to find her. And so I don't know how to serve her since I'm the only one that she doesn't run from.
Well, so let me ask you this. She signed that she had received a copy of your minor guardianship petition. Is that correct?
Yes.
Okay. And then she also checked the box that she did not want to be notified about the court's hearings or decision in this case.
Yes.
And so Mr. Phelps, on the other hand, had indicated he does want to be notified. And he is present here.
Yeah.
Yes.
Okay. So what still needs to be served?
I'm not sure. She was provided a copy of everything that I had, as far as all of my court documents.
Ms. Farr, is there something else that she needs to be served with?
No, we just need to get the proof of service filed, but the fact that Molly is the one that served her is an issue because it wasn't by a third party.
Oh, Ms. Curry, you served it on her.
Yes, because I'm the one person, I'm her mom. She won't run, she won't run from me, but she will.
So I was explaining she could sign an acceptance of service from Molly, but she doesn't believe she can find her again very easily. So, and that's what I was going to talk with Father about too, is just signing the acceptance of service.
Okay. Yeah, that is.
Yeah, I got no problem signing that.
Okay.
And then, I know that where Molly has to go to try to find Emily is she's putting her and Lila in danger, having to go do that, because she's not where she hangs out it's a place I don't want to go.
Yeah.
And for her to have to do that it's really unfair, I think. Okay. But yeah, me and Molly are we're working together on this. Like we've got everything, we're copacetic with, what's best for Lila and,
and Ms. Farr can certainly speak with you, ma'am, about this, but one of your options is, I believe you can hire a process server or ask law enforcement to serve these documents if safety is a concern.
The problem, Your Honor, is that she is homeless and she hangs out where there's some transitional housing, which includes homeless and drug addicts. And so it's kind of an unsafe environment, but she doesn't have a residence. She just hangs out. What we do have is a mailing address for grandmother where she accepts legal documents, but mother hasn't consented to that address being used, but she does retrieve other legal documents from grandmother. So I was explaining to Molly that we could possibly do service by mail, but that takes, the period is longer than the 20 days to be able to enter the order then at that point. So.
Right. Okay. Well, Ms. Curry, I guess what I would say is work with Ms. Farr before our next hearing on brainstorming what those options are. And then if you all bring back to me kind of a statement of where you're at with service and it's something that's still just we can't effectuate in 3 weeks, we can talk about alternative arrangements that keep everyone safe, but still abide by the legal requirements I have to find. Okay.
Okay.
Okay. Does that work for the parties?
Yeah.
Okay. Mr. Phelps, I appreciate you being here. What we'll do is set this to November 7th at 10:30, I will extend the immediate order through that date. So Ms. Curry, the emergency minor guardianship order will be in effect for that period of time through our next hearing date.
Okay.
Anything else we need to do on this case? Thank you all for working so diligently. It sounds like there's a couple hiccups, but I don't think anything we can't overcome with a little bit of time.
Okay. Sounds good.
Okay. All right. Thank you both. You're
Yes,
free to log
Tyson.
out.
Thank you.
Tyson, thank you. And let's see, who do I have present today?
Annalyn is the one that's doing it, and I'm just her daughter. I'm here for support.
Okay. I'm going to open that up. I'm not seeing anyone else present on this case. And I'm noting, at least from my review, no service of documents on the parents, and on the original petition, I believe there's not even an indication of who the father is.
Correct. He hasn't really been in the kids' lives for a few years, and last we've heard he's been on the streets, so we don't even know where he is. He's
So for purposes of minor guardianship, we can't do anything without service on both parents, unless parental rights have been terminated through a dependency proceeding or some other action. My hands are tied. You have to list both parents and you have to serve both parents. You have to make attempts to serve both parents. What I could do today, because I do see you have filed everything else, including the bankruptcy and criminal history disclosures. We have the motion and order signed for DCYF to release information. I'm looking to see, I believe the immediate order was signed by Judge Hahn here. So what I can offer you is an appointment of a court visitor to help talk to you about how to get everyone served and help you with that process. Do you want me to do that?
Yeah, sure. But the only thing is we don't know where the father is because he's in jail. And then my daughter, she's in jail also right now.
Yeah. So the court visitor can help you. So that's not uncommon. You probably heard from other cases. Oftentimes in minor, especially emergency minor guardianship cases, finding parents is difficult, but I can't waive that requirement, especially right now, without you all undertaking a lot of due diligence to try and find the parents. And so it's not a point, we're not at a point where we could move forward. The only thing I can do is appoint you the court visitor and give you a new court date today. I can extend the immediate order through the date of our next hearing.
Okay. So we know where the current mother is. She's currently in Cowlitz County.
Yeah, I can't. So here's the thing. I'm the judicial officer who's going to decide the petition. I can't give you guidance on how to serve or when to serve or who to serve. What I can tell you is you need to serve both parents. Okay. So I'm going to appoint you a court visitor that can help you through that process. I can't be the one to help you through that process. Okay. Let me ask a couple questions so we can find out if this is something the county is going to pay for or if you will be responsible for the court visitor payment. So the main guardian, is that Annalyn Glenn's?
Yes.
Yes.
Okay. What is your current income?
Maybe about 30, 35. I work as a caregiver right now.
About $3,500 a month?
Yeah, 30, 35, yes.
Okay. And you said, and that's per month?
Oh, no, I'm sorry, for a month, about 25 to 28.
So what's the 30? So help me understand. When you say 25, are you talking about $2,500 a month?
Yes, ma'am, yes.
Okay, so what's the 3,500 a month? What
Oh,
were
no,
you?
that was, I thought it was 35,000 for a year or something like that.
Oh, okay. So about 2,500 to 2,800 per month?
Yes.
Okay. Do you receive any sort of state or federal assistance that's based on your income level, like a needs-based program?
No, I don't at all, no.
Okay. And any like social security benefits?
No, I don't. I'm receiving like part of my ex-husband kind of retirement. So that's part of my income.
And is that so do you receive additional money on top of the 2,500?
No, that's included in it. That's
including, okay. And how many dependents do you support?
None, just the boys now that they have been living with me for about 5 months or more.
Okay. Just a second here. So the court visitor fees are, I believe, $67.50 an hour. And usually we put at this stage, there's usually not more than 8 or 9 hours that would be put into it. That would kind of be the cap. Is that something you think you could afford at this stage to help you get service effectuated?
So it takes roughly 8 hours for the.
I'm just saying a max. I don't know. I'm just giving you kind of a kind of cap. Is that something you would be able to afford?
About $500. Yeah, I think I can save that for.
Here's what I'm going to do right now. Just as of today, I am going to order, I will issue the order appointing a court visitor. What I'll do, because you're with having 2 dependents, which you do temporarily right now, you're closer to the guidelines. I don't think I would find you indigent. But I obviously understand you have other expenses like living and food and housing, especially with these 2 boys. So what I'll do is split the cost 50-50 between you and the county. So the county will cover 50%. You'll be responsible for 50%. So, $30 some an hour versus the full $67.50. Okay.
Okay, that would be great.
Okay. I'll put a little notation in there that that's subject to revision if, your income changes at any point during this hearing. But for now, I think based on what you're telling me about your income today, I think that makes the most sense so that you can still take care of yourself and the boys pending this petition working its way through. Okay. Okay. I don't know exactly who the court visitor will be, but the court will reach out to you and let you know who gets assigned to your case. Okay. Let's set. I'm going to say in your case, I'm also thinking about 3 weeks since we don't have any service done at all. And it might be difficult to find people. I'd rather set you out a little further than have you come back and have to just give you new court dates. So can you come back via Zoom November 7th at 10:30?
Okay, will do.
Okay. I'll get those orders entered and we'll see you back on November 7th.
All right. Thank you so much.
All right. Yes, thank you. You're free to log out.